This courtroom exchange may sound procedural at first, but make no mistake, this is a high-stakes legal chess match unfolding in real time. At the center is Mr. Estrada, facing an aggravated robbery case where identity is everything. No fingerprints, no clear facial recognition, just a masked video, a co-defendant, and a girlfriend whose testimony could make or break the case. What you're about to witness is not a jury trial, but a fight over fairness over where the defense counsel is being forced into trial. Without adequate notice or access to discovery, the defense insists preparation is everything. The prosecution insists nothing new changes their case. And the judge, she's clearly not interested in gamesmanship. Layered into this dispute are explosive side issues. Allegations of witness interference, forfeiture by wrongdoing, jail calls, and whether telling someone not to show up crosses a legal line. The tension here isn't dramatic by accident. This is what happens when timing, discovery, and trial strategy collide under a ticking clock. Stay with this, because what sounds like a scheduling issue quickly turns into a debate about ethics, fairness, and how far the law will go to prevent abuse of the system.
I prepare ahead of time. I am sure that for the state, this discovery is not important. It doesn't go to their theory of the case. Of course, it goes to Mr. Estrada's right to have an effective defense. I do prepare. I want to look at the discovery. I don't know what it is. And I'm not asking for an inordinate amount of time. You bring me back 2, 3, 4 weeks, I'll be ready. I see you shake your head no.
No, not 2, 3, 4 weeks.
Oh, okay. But what I'm telling you is that I may be, and if you say next week, that's fine. It isn't a question. I want to do the right thing the right way. I want to look at the discovery. And Judge, if it doesn't make a difference, of course I'll be ready. If it's earth-shattering, but it'd be different. Now, there's some other tangential issues that you've already indicated in my motion that are not a proper ground. Fair enough. We can have that.
What would that be?
Well, there's a audio tape where some witnesses say to Mr. Estrada that they came by and served us on a murder. This is an aggravated robbery case. And they say, it's not the case you were thinking about. And he says, don't show up on that murder. Now, I think there's a good question whether or not that's wrongful, telling someone not to show up for an different case. That's an issue that I think in the next week I'll be better prepared for. The next 2 weeks or whatever you tell me. And I'll await your ruling on that. And I want to be prepared for that. And I will be prepared for that as well. But the reason I'm asking for time to review the discovery they've uploaded is I know it's not important to them, but I think that a week or whatever you give me is a proper amount of time for us to look at it and me tell you, Judge, I'm ready now.
Laying its cards on the table, and it's a risky but calculated move. By framing this as a pure identity case, counsel is essentially saying, if the girlfriend doesn't identify him, the state's case collapses. That's a bold stance, especially when the only other identification comes from a clerk claiming to recognize someone's eyes through a mask. Courts routinely scrutinize that kind of identification, and juries tend to be skeptical. But here's the key detail. The defense is asking for time not because they're unprepared, but because strategy depends entirely on what evidence exists or doesn't. No fingerprints, no physical linkage. Everything hinges on who the jury believes. This is where viewers should ask themselves, if you were on that jury, would eye recognition and relationship testimony be enough to convict beyond a reasonable doubt? Or does reasonable doubt loom large?
Judge, I'll address the forfeiture by wrongdoing first. So, Judge, they do talk about a murder case. My understanding is that our investigator did slip of the tongue because there was another murder case on the docket that he did mention murder. But in the phone call, which I don't believe defense counsel had the full opportunity to listen to because they walked away to go talk to their client. Sorry, Diana. That he mentions, regardless, I'm going to get 25. Don't show up. If you guys show up, they can prove my case. So they know that it's in regards to the cases that we're alleging against him. And he repeatedly says, please don't show up. He talks about the consequences of if they do show up and present testimony in this case, and they aren't here. They were served yesterday. And were given notice to be here. In regards to the second issue, I did tell Mr. Brobenick that this was information related to the co-defendant's cases in the fact that it was evidence specifically linking the co-defendant. I don't believe Mr. Estrada gets brought up in these other cases. I did see that he has a hard drive. I can upload that right now. And
so you're saying this co-defendant is evidence, the co-defendant's information that you're uploading is evidence that links Mr. Estrada to this case?
No, it links the co-defendant to the case. I don't believe Mr. Estrada is really linked through that evidence.
This is a textbook example of why discovery disputes matter so much in criminal trials. Defense counsel isn't accusing the state of misconduct. He's saying he doesn't know what's in the newly uploaded material, and that alone is the problem. Under the law, the defense, not the prosecution, gets to decide what's material to their case. The moment new evidence appears, even if the state claims it's unrelated, the clock resets in a meaningful way. An effective defense requires time to review, contextualize, and adjust strategy. The judge is clearly weighing efficiency against fairness here. This raises a critical question for viewers. Should courts prioritize staying on schedule, or should even last-minute discovery automatically slow things down to protect constitutional
Already uploaded?
rights?
Yes, ma'am. There was significant evidence that was uploaded in this case and the other cases that Mr. Propnick was already assigned.
All right, and the evidence that was uploaded that you say is already uploaded and you're saying significant, what do you mean by significant?
So it was just all the cases had their own e-discovery links. And so it's just each case, it's just more and more evidence for whichever specific case. But when linked together, the evidence that was previously uploaded, that's our case. You know, we're not going into the new stuff. I'm not going to present any of the evidence that was uploaded later.
So the evidence that you're saying was uploaded, has he already had access to it?
Yes, ma'am.
I don't know if I have or not. What I do know is that I am now being placed in a position where I haven't looked at what they're saying. It isn't whether they're going to present it, it's whether it's material to our defense. And I don't know, Judge, but what I do know is that I prepared by uploading each and everything in the case to this drive. And when there's additional information, I'm very concerned about going forward. It's the whole reason that we signed those discovery acknowledgements, which I cannot sign today.
But what he's saying is that it's already been uploaded and it wasn't just uploaded today, that you already have it.
Well, everything that is on this drive is what has been uploaded in this case, and I am on notice that we are trying today. I believe that evidence, it might be to another case, might be somewhere else, but I asked them, and I've been in open court and said it, I want every piece of information on this case. So if they're intending on bringing information from other cases, that was the reason that I went here
Now
today and
the
said,
prosecution pushes back, and notice how carefully this is framed. They emphasize that the new material links the co-defendant, not Estrada, and insist they won't introduce anything newly uploaded at trial. On paper, that sounds reasonable. But from a defense perspective, that assurance isn't enough. Evidence involving co-defendants can still indirectly implicate a defendant, shape narratives, or affect cross-examination strategy. This is where courtroom trust becomes fragile. The judge starts probing, what exactly is significant evidence? And has the defense already had access to it? This moment underscores a recurring courtroom tension when one side says, trust us, and the other says, we can't afford to. Who do you think should bear the
subpoena
risk
being
here?
requested or issued.
So is your argument that if there are witnesses in a case, unless they're subpoenaed, a defendant can tell a witness, don't show up?
Well, if a person has not been subpoenaed, the law allows you to tell them you don't have to show up.
No, not you don't have to show up, but tell them not to show up. That's what the allegation is, that he told a witness not to show up, not that you don't have to show up. I've been a defense attorney and I know that people have told people, hey, you haven't been subpoenaed, you can show up or not show up. If you've been subpoenaed and you don't show up, one or two things are going to happen. Either the state is going to be like, well, whatever, they didn't show up, or either they're going to want to do an attachment.
So I am returning to what I know to be the law. And the law is that we are entitled to two things. Number one, all the discovery on a case that we've...
I'm talking about the asset, the forfeiture.
So the forfeiture by wrongdoing, I do not know whether, because and I have a case here that the standard is that it has to be wrongful, right? And so the question is it wrongful? Well,
the question is it wrongful to tell somebody that they don't have to, that they don't show up to court? Is that wrongful to tell somebody, do not show up to court? If you show up to court, then I'm looking at 25 years. Is that wrong to do?
I believe that is the question. If that is in fact what it said, which of course is the real problem we have
This
here.
is where the hearing takes a dramatic turn. What began as a discovery dispute morphs into a serious legal doctrine, forfeiture by wrongdoing. The judge's hypotheticals are deliberate and devastating. If defendants could simply call witnesses the night before trial and tell them not to show up, the entire justice system would grind to a halt. The judge isn't accusing Estrada of doing this, she's stress testing the logic of the defense argument. Her experience as a former prosecutor adds weight here, especially in family violence cases where witness intimidation is common. This exchange reveals why courts take alleged witness interference so seriously. Even without a subpoena, telling someone don't show up can cross a legal line. The big question, where should the law draw that line?
If your trial is on, let's say, hypothetically, February 6th, you can call somebody on February 5th and tell them not to show. And then the defense attorney can say, excuse me, I need more time. I'm just learning about this. And then let's say hypothetically, that person gets a continuance and their continuance is, let's say it's for March 12th or whatever. I'm just doing a date. And so that defendant knows their court date, their trial is set for March 12th. So they say, you know what? Let me make a phone call. And they make a phone call on March 11th, telling somebody not to show up for court, because if you show up for court, things are not going to go well for me. And then the defense attorney can come in and say, hey, I just learned about this last night. So are we going to do a situation, hypothetically, where defendants are allowed to call people the night before their trial, tell them not to show up for trial, and then everybody gets a continuance because I'm just learning that they told somebody not to show up for trial? And these are just questions I have, Mr. Estrada, and these are hypothetical questions. I'm not saying you did that. I don't know. No evidence has been presented of me, but I'm just trying to figure out everybody's.
This is one of the most candid moments you'll ever hear in a courtroom. Defense counsel openly admits uncertainty about the current state of the land. The judge respects that honesty, but she also asserts her own command of forfeiture doctrine, explaining how and why courts address last-minute witness manipulation. What makes this moment powerful is its transparency. This isn't about winning an argument, it's about figuring out the correct legal path forward in real time. The judge signals openness to new authority, but not to delay tactics disguised as confusion. It's a reminder that judges aren't passive referees, they actively safeguard the integrity of proceedings. Should uncertainty automatically justify delay, or does experience sometimes outweigh hesitation?
And Ms. Ferguson will tell you, on family violence cases, you would think you have a witness, they've been subpoenaed, then all of a sudden they don't show up. You check jail calls, and the night before, whoever the defendant is has called that person and said, do not show up to court. If you don't show up to court, they're going to have to dismiss the case. And you know what I would do? I would play the DVD in court and say, here's your motion. I'm doing an affidavit. I'm doing a forfeiture.
The law didn't change, in fact, since you've been a prosecutor, because I know you've been a judge at least 4 years, right?
Yeah, more than that. But I always try to keep up to date on law. So I reviewed it.
So your specific hypothetical was about when you were a prosecutor and you knew the knowledge was from back.
Oh, but here's the thing. I'm telling you that because I have background and forfeiture by wrongdoing, and I always keep up on forfeiture by wrongdoing. And the reason why I do that is because I'm anticipating that usually that happens in family violence cases. So I always check the law every now and then. And then, hey, who knows? Maybe something's changed since yesterday. If it has, I'm willing to be presented with that and keep an open mind on it. I'm always for following the law.
Well, so it has changed since you were a prosecutor, which is where you let me know, and it changed in 2021. I can't tell you in this specific fact because I've done not a briefing. But you had already indicated to me off the record that you were not going to grant a continuance on this particular ground.
No, not because you've got new information that your client
alleged. This showcases how quickly procedural issues can escalate into constitutional debates. At its core, this case balances two competing principles: the defendant's right to an effective defense and the court's duty to prevent manipulation of the justice system. Identity evidence, late discovery, co-defendant overlap, and forfeiture by wrongdoing all collide in a single pretrial moment. The judge makes clear she won't grant a continuance based on alleged witness interference, while still acknowledging the seriousness of discovery obligations. The broader takeaway: preparation matters, but so does timing, credibility, and respect for the process. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.